Let's set the scene. Picture yourself walking through a grand, sunlit marble courthouse. You're following a lawyer, moving purposefully past these heavy, imposing wooden doors. They're carrying a massive binder labeled Rules 1 to 56, Civil Procedure. They stop, open a folder, and, with dust motes literally dancing in the warm, cinematic light, reveal a single, powerful document. It's incredibly dramatic, right? Well, behind that kind of movie magic sequence is actually a rigorous, mechanical process. Welcome to The Explainer. Today, we're diving into Willard B. Riano's bar lectures and the 1997 Philippine Rules of Civil Procedure to map out the exact anatomy of a civil lawsuit. Here's a quick look at our roadmap today. We're going to cover 1. The rules of the game, 2. The cause of action, 3. Summons and due process, 4. Pleadings and defenses, 5. The mandatory pretrial, and 6. Trial and judgment. Let's jump right into Section 1, the rules of the game. So to really get this, we have to separate the legal world into two buckets, substantive law and remedial law. Think of substantive law as the thing that actually gives you a right, like, say, the right to claim damages if someone breaches a contract with you. But remedial law, specifically civil procedure, that is the actual playbook. It prescribes the exact step-by-step methods you have to use to enforce that right in a courtroom. Because honestly, you can have all the substantive rights in the world, but without remedial law, you literally have no way to exercise them. Now, the overarching philosophy behind all these procedures is laid out right at the beginning in Rule 1, Section 6. It explicitly states that these rules should be liberally construed. So what does that actually mean for us? It means they don't exist just to create some bureaucratic nightmare or to trap people in endless technicalities. The ultimate goal is to secure a just, speedy, and inexpensive disposition of every single action. The rules are just the vehicle, justice is the destination. And here is what that journey looks like from a bird's eye view. The timeline of an ordinary civil action flows from the complaint to the summons, the answer, the pretrial, the trial itself, and finally, the judgment. Moving right along to Section 2, the cause of action. Every great legal drama needs an inciting incident, right? Under Rule 2, that's called the cause of action. It's the specific act or omission by which one party violates the right of another. And this is absolutely crucial. Without this specific violation, this initial spark, you just don't have a basis for a civil lawsuit. You can't just sue someone because you're annoyed with them. They must have actively violated a legally protected right of yours. Once they do, bam, you file your initial pleading, which is known as the complaint. Which brings us to Section 3, summons and due process. Okay, so once that complaint is filed, the court has to officially pull the defendant into the process. Imagine that lawyer from our opening courthouse scene pulling that formal summons out of their folder. A summons is a court order directing the defendant to answer the complaint. But guys, it is so much more than just a piece of paper. It represents strict compliance with the constitutional rule on due process. Without properly serving this notice, the court simply cannot acquire jurisdiction over the defendant. It's the ultimate safeguard that ensures you can never be secretly sued in the shadows. But let's look at a really practical, messy, real-world scenario. What happens if the defendant knows the lawsuit is coming and literally goes into hiding to avoid being physically handed this document? Do the wheels of justice just stop turning? Thankfully, no. The rules adapt through what's called substituted service. But the requirements here are incredibly strict. The serving officer has to formally prove that prompt personal service was impossible within 30 days. They have to meticulously document at least 3 failed attempts to find the person on at least 2 different dates. Only after checking all those boxes can they leave the summons at the defendant's residence with a competent person over 18 or at their office with the person in charge. So the law bends to reality for sure, but it fiercely protects due process while doing it. All right, Section 4, pleadings and defenses. You can think of this phase as a highly structured paper war. The defendant is officially summoned, and the battle lines are drawn. Now, the parties have to assert their claims and defenses through very specific documents. The plaintiff files the complaint, the defendant files the answer, and we might see counterclaims or cross-claims thrown into the mix. And this all happens within unforgiving deadlines. For example, under certain summary rules, a defendant might only have 10 days to file their answer. Miss that deadline, you risk being declared in default. It moves fast. Now, during this phase, you might run into one of my absolute favorite pieces of legalese, the negative pregnant. It sounds weird, I know, but a negative pregnant is basically a specific denial that is so oddly phrased, it becomes pregnant with an admission of the core truth. Imagine the complaint says you stole the money on a Tuesday. If your official written answer is just, I deny that I stole the money on Tuesday, well, legally speaking, you might have just accidentally admitted that you stole it on Wednesday. It's a massive trap, and it teaches us that absolute precision in these documents is critical. Up next is Section 5, the mandatory pretrial.
Picture our lawyer stepping through those heavy wooden doors into the pretrial chamber. I cannot stress this enough. The pretrial is absolutely mandatory. It's the strict filter designed to streamline everything before it ever reaches a full-blown courtroom trial. The judge really pushes for an amicable settlement or mediation first. If that fails, they simplify the issues, get both sides to stipulate basic facts so no one wastes time proving them later, limit the number of witnesses, and pre-mark all the evidence. And here's the kicker. If you fail to appear at pretrial without a rock-solid excuse, your entire case can be dismissed if you're the plaintiff, or you waive your right to present any evidence if you're the defendant. High stakes.
And that leads us to Section 6, trial and judgment. Rule 30 mandates a very strict chronological order for the trial itself. The plaintiff goes first to present evidence supporting their complaint, then the defendant gets their turn. Next, any third parties present their case. After that, parties can offer rebutting evidence. It's this highly structured, methodical dance to ensure every single party gets their proper day in court before the case is submitted for decision. But there is a fascinating tactical shortcut called a demurrer to evidence. Imagine the plaintiff finishes presenting their whole case, and it's just fundamentally weak. The defendant can immediately file this motion, essentially standing up and telling the judge, look, even if everything the plaintiff just showed you is 100% true, they still have no legal right to relief. If the judge agrees, it is a mic drop moment. The trial is stopped dead in its tracks and the case is dismissed right then and there. Now let's assume the trial does go all the way to the end. Once all the evidence is in and the case is officially submitted for decision, the clock starts ticking. The rules mandate a strict 90-day window for the court to render its judgment. That grand marble courthouse we imagined, it operates on a very tight schedule to ensure justice isn't delayed. As we wrap up this journey through Philippine civil procedure, I want to leave you with a thought to chew on. Does rigid adherence to these procedural steps perfectly protect our constitutional rights? Or does the dense technicality of remedial law, the strict deadlines, the negative pregnance, the mandatory appearances, did those things sometimes become a barrier to true substantive fairness? It's something to keep questioning as you look at the rules of the game.